401 and 402.
And exactly what are they?
State's Exhibit number 400 is applicant process unit records from the Dallas Police Department related to the defendant, and it was tendered to the defense attorney and under business records affidavit on August 9, 2019. Applicant process unit records. These are going to be the application file from the defendant's first attempt to apply to the Dallas Police Department.
You said her first attempt to apply?
That's correct, Your Honor. There were two. She applied multiple times.
And 401?
401, Your Honor, is going to be the defendant's personnel file, and this contains, again, also under business records affidavit that was tendered to the defense on August 9, 2019. And this file contains background information provided by the defendant throughout the application process through the Dallas Police Department, including her social media Pinterest account name. It includes the polygraph information related to her application to the Dallas Police Department as well, and statements and things that she's made.
You said a polygraph?
That's correct, Your Honor.
What was the nature of the polygraph?
The defendant failed her first polygraph for the Dallas Police Department.
Well, generally speaking, polygraph.
And not to admit the actual contents of, I guess, the polygraph itself, but the fact that she failed it, and that was part of the reason why she applied the second time. The Dallas Police Department allowed her time to reapply.
Are you alleging that there's something pertinent to the social media?
Yes, Your Honor. There are certain posts that were made by the defendant on her Pinterest account that I think is relevant for the trier of fact to consider. In States 402?
Yes.
That's going to be a copy of the defendant's internal affairs file, a division file from the Dallas Police Department. And particularly within that file, there are certain allegations for misconduct that were sustained against the defendant, or that she received counseling for. That she received counseling for.
Okay. You've had an opportunity to review State's Exhibit 400, 401, and 402?
Yes, Your Honor.
And may I see those, please?
Yes, Your Honor.
And under what basis are you proffering these?
All purposes, Your Honor.
Which one is this?
That should be 401. This is 402. And then this is 400.
No, I need a few more minutes. Well, let's go in numerical order here. Mr. Rogers, what is your objection to State's Exhibit 400?
Judge, 400 is an application from 7 years ago that, one, it's not relevant. It was so distant in time from the conduct that is the subject of this case. Also, it contains unadjudicated, admissions of unadjudicated offenses and acts, or it contains admissions or references, traffic tickets, smoking marijuana, things like that are that the state should have to prove each and every act beyond a reasonable doubt. So it's has a considerable amount of hearsay as far as the reasons for that she was rejected. That was hearsay from other officers.
Okay, wait, we're talking about
State's Exhibit 400, that's just a 2012 application, Your Honor. The other stuff is the personal file, that's
Yeah,
gonna be 401.
because I don't see any of that.
In State's 400, Your Honor, it mentions the fact that the defendant was denied by the Fort Worth Police Department, and that's the first application for the Dallas Police Department.
And Judge, that's hearsay. We have to, it's hearsay. We don't know the context of what the Fort Worth Police Department decided, and it's not relevant, Judge.
And if I may respond, Your Honor, these are admissions made by the defendant. This is information that the defendant wrote on application seeking employment of the Dallas Police Department.
I found the Fort Worth reference where she is asked, have you ever applied with any law enforcement agency or fire department or related work, including cadet or explorer? And the answer was yes. And then it asked for the date, position, and disposition. And she indicates that she applied to the Fort Worth Police Department and was denied to be a police officer. And there was another application to the DFW Airport Police, although it doesn't indicate a disposition.
And that's correct, Your Honor. There are no references in here to any. Oh, here. Have you ever smoked or experimented with marijuana? The answer is yes, on 3 occasions, beginning in July of 2009 and ending in June of 2011. Supplemental concerning drug usage, where there's an indication that it was never purchased by her or never possessed more than 4 ounces. First time she was right out of high school with friends, and then allegedly 2 times in 2011 at someone's birthday, a friend's birthday. And this was completed on August 23rd of 2012. That's correct, Your Honor.
And Mr. Rogers, your objections to 400?
Just her admission that she was denied by the Fort Worth Police Department is not relevant. It's more prejudicial than probative. Her admission of marijuana usage and the subsequent discussion of that in the application process, again, is not relevant and more prejudicial than probative.
Let's look at 401.
Yes, Your Honor, that's the personnel file. And the state, I know it's quite voluminous, Your Honor, and the state, in order to not create a situation, and especially in regards to the polygraph, the state, as far as 401, there is a page in there that mentions the defendant's social media accounts where the defendant self-reported which account she had and the names of those accounts. If that is the only page of state's 401 that the court would allow, the state is fine with that.
Okay, so just so we're clear, allegedly this exhibit,
State's 401.
401, contains 334 pages.
That's correct, Your Honor.
And there are a host of flags that you...
That's correct, Your Honor. And I can point out exactly which one is the social media if the court would like.
Well, I see you have a
Tag
tag
that
in your
says-
social media. And I'm presuming that the city of Dallas did the redaction of the
Yes, Your Honor.
identifying information.
That is correct.
Place it first. Okay, so where you have social accounts, are all of the pages subsequent to this, how many pages?
No, Your Honor, just that pages. Where
Just
it
this
lists-
one page,
Where it lists down here.
where it lists Pinterest,
That's correct.
Groupon,
That's correct.
and is it Score Center?
That's correct. And the usernames for those different accounts.
Of this entire personnel file, you want this one page? Have you?
There's more information in there, but I believe, as the defense has mentioned, that there are some objections to other things, and including, more specifically, there was the polygraph that the defendant, that's listed within that state's 401. The relevance or the purpose for the polygraph is that the defendant failed her first polygraph, but that, of course, was related in connection to the usage or the recency of usage, amongst other things.
So the examiner asked the question if, I think it was 2011 was the last time you used, let me just make sure everything. If your last marijuana usage was 2011 in June, is that the question that she failed on the polygraph?
It's that in subsequent, so there's two polygraphs, there's different dates given, different time frames that are given, and then maybe some mentioning of any other sort of, I guess, crimes that may have been committed.
In the polygraph? They were not identified on this application?
That's correct, there aren't any crimes at all, Your Honor, but it's just self-admissions and self-reporting to.
Did the examiner elicit what the crimes were?
Yes, it was self-reported, Your Honor.
Or-
And it wasn't actually, so we're discussing a theft that occurred at her prior
It was a
business location. She worked at TGI Fridays.
She admitted she stole or took a pencil and a brownie without permission.
And so those things were what led to the issues with the polygraph.
A pencil and a brownie?
That's correct, Your Honor, and the state's not wanting to admit, not
So
wanting
you're
to
not-
get into any of that. That's correct.
Well, let me be clear, you want to proffer that she failed the polygraph, but you don't want to say it was for the theft of a brownie and a pencil?
Well, if the court will allow such things, then the state can, but we don't think that that's really a pressing issue.
Okay. It's hard for me to line up with the polygraph. What are the pressing issues from?
Those were the only things with the polygraph, Your Honor, and the personnel file.
Okay. And you want this single page that identifies 3 social media outlets?
Yes, Your Honor, that's correct.
Score, Center, Groupon, and Pinterest.
That's correct.
Mr. Rogers?
With regard to the, I'm kind of unclear, but if we're,
I haven't made decisions,
Right.
I'm inquiring, trying to understand the
if
scope.
she's just offering one page from the personnel file that you just identified that has the 3 social media accounts, then I don't have an objection to that.
To that portion of her personnel
To
file?
have one page.
No objection to the one page identifying the social media account?
That's correct, Your Honor.
That's all you want out of this personnel file?
Yes, Your Honor.
Okay, that'll save me some time in reading all of this. Okay. State's Exhibit 402.
State's Exhibit 402, Your Honor, is also from the Dallas Police Department under Business Records Affidavit, dated for August 9, 2019, and this is the Internal Affairs Division file related to the defendant. And particularly within this file, the state would like to admit before the jury the sustained allegations against the defendant based on departmental violations.
Do you have those flagged? Because this is another voluminous exhibit that
Yes, Your Honor, I can tell you exactly what there was. There's control number 2018-183.
hold on, you have some tabs here as well,
Yes,
but they're not marked as they were in the first one.
that's correct.
Is the blue one significant? Oh, you got pink, blue?
Yes,
and
they're just
green.
different, yes, Your Honor.
Okay. Well, let me just go to the first pink tab. Are you there? Oh,
I am. I was gonna say, if it's okay for the court, I can direct you to the ones exactly, because they should be listed in, okay. The first one, Your Honor, is going to be the defendant received a sustained finding through an internal affairs investigation for adverse conduct, violating Dallas Police Department Code of Conduct, and it's gonna be under control number 2018-183,
Okay.
which should have a date of September 24, 2018.
Yes.
And this
I'm
is the
there.
control number that resulted in the defendant's termination of employment with the Dallas Police Department.
I'm sorry, restate that again?
This control number and violation is directly resulted in the defendant's termination of employment from the Dallas Police Department.
This one, which identifies, all I have on here is January 11, 2017 DVR program violation.
And that's another one, Your Honor.
Counseling. September 25th, 2017, a chase policy violation.
And that's another one, Your Honor.
Okay. So I get, you mean the page behind?
That's
this
correct,
page?
yes,
Okay.
Your Honor.
Failing to see. So here's the first pink
Yes.
tab up to the next green tab.
And there, and that's why I said I can give you the list of the dates, because the way that we received it from the police department, it would be helpful for the court to have the dates so that you can pull those out.
Well, I want to know exactly what it is from this
Okay.
that you wish to put in the evidence. So Mr. Rogers can be well informed and make whatever objections he'd like. Mr. Rogers, you have a copy of the disciplinary action that took place on September 24th, 2018,
Yes, yes, Your Honor.
and your objections to that?
Yes, Your Honor. With regard to investigation control number 2018-183, The report contains actions completed by other officers and reports of officers that is hearsay within hearsay. The report also contains Garrity information derived by my client that normally the district attorney's office has redacted, but in this case, there's a page there's a part of the investigation which says what Amber Guyger summarizes Amber Guyger's internal statement. That's a violation of Garrity v. New Jersey.
Wait a minute, I haven't seen this.
The Garrity information.
I don't, I
It's
haven't
been
read
redacted.
every document she just handed me for this investigation, but I have not seen the Garrity information as of yet.
Garrity information has been redacted from the state's file, just so that the record's clear. The defense received the full file.
Just when I see what they offered.
The first section she gave me, I've gone through, I haven't gone through the second section, but in the first section, I didn't see any Garrity.
Judge, under investigation, it says officer testimony. It's a summary of her internal statement.
I don't see any officer testimony.
It says, Judge, it says officer testimony.
I know that's what it says, but it just lists, it just states September 9th, Officer Guyger was placed under arrest in Kaufman County by the Texas Rangers and booked into the Kaufman County Jail for the charge of manslaughter.
Right,
That's the sum total of officer testimony.
right. That's my client's statement. It's the internal statement provided by Amber Guyger on whatever date that was.
This is her statement. She said to them, I was arrested.
Right.
You don't think they could have found this information from some other source?
I know they could have,
There's
Judge.
not a reference
To any statements that are made.
except for this heading.
Well, Judge, I can, normally they redact that because that is the investigator's submission of a summary of Officer Guyger's internal statement. Whether they could get it, of course they could get it from other sources, but they included it in there, and that is a violation of Garrity v. New Jersey. The statement that she gave was she was told that that statement, nor the fruits of that statement, could be used against her in any criminal proceeding.
I don't understand how this is her statement. It is literally a factual recitation of what happened on September 9th, 2018.
Right, Judge. They asked her to give an internal statement asking her if she was arrested. They gave her the Garrity warning, and she gave a statement admitting that she was arrested.
Judge, and the state doesn't, defense attorney is correct that typically, and as is followed in this case, for public integrity, the file is redacted of Garrity. Neither have any of the prosecution teams seen any Garrity statements made by the defendant. I couldn't even tell you what was in a statement, let alone, I guess, if there was in fact one.
Judge, that is a summary of her internal statement. I know it's short, but it's in there. And
I'm having a hard time grasping that this is testimonial or provided subject to interrogation, because it just states on a date certain she was arrested in Kaufman County by the Texas Rangers and booked into the Kaufman County Jail.
right above that, Judge, it says
I see the heading.
officer testimony.
It
Is that
says investigation, officer testimony. So you want to object to this paragraph where they summarize what allegedly happened on September 9th.
They are, the way,
Categorizing that as her officer testimony.
the way they write those investigations, Judge, and I've seen hundreds of them, is they're going to say, here's what the officer testimony is related to this. The only officer testimony in this case was Amber Guyger's, and they put her statement in their summary. That, regardless of what information is in there, it still is a violation of Garrity v. New Jersey. And Judge, we don't have the actual investigator here, I think it was Sergeant Criddle here, to explain the context of the investigation. Furthermore, it contains, hearsay, the booking. Well, are you offering this?
No.
So
I'm presuming you want these 1, 2, 3. Four, 5.
fired because she was arrested for manslaughter. And so we don't.
There's another page that says essentially that.
I guess, for your honor, if the defense is concerned with these documents going before the jury and actually being taken back, the state will withdraw State's Exhibit number 402 out of an abundance of caution. But what the state would like to do is still talk about the pages that list whether or not there was a sustained finding for an allegation. That is a one-page that looks like.
It is 1 page.
It's a one-pager, there's no other information, it just states what the violation was and whether the allegation was sustained or not. Like this right here. Oh, well, here, I'm sorry, Judge.
Well, so this is the statement of Major Ramirez with his findings with internal affairs. And so the information gleaned in here, one is that it implies that there was some type of investigation into this adverse conduct, and that it leaves open. We don't know what Major Ramirez's thoughts are.
Let me see that first portion that you provided to me.
And also, it's just the fact that there was a warrant. We know she was arrested. The fact that there was a warrant for manslaughter and that she was put into the Kaufman County Jail. The ranger has already testified in response to whether or not he believes today there's probable cause for that same offense. And the findings of Major Ramirez are hearsay, and the actual conduct and acts that it's talking about are the fact that she was arrested for manslaughter and booked into the Kaufman County Jail, and that's more prejudicial than probative.
Or here is so you allege that part of the administrative investigation included testimonial evidence from Ms. Guyger. Is that correct?
Yes, Your Honor.
All right. Would this be sufficient that this portion here that begins, as a result of her actions, Officer Guyger shall be held accountable for the following rule violation. And then they state the code of conduct violation, and then their findings. So in essence, these last 2 paragraphs, this sentence, and that doesn't have any testimonial or alleged. I have the rest of this. I was reading through it, and there are references to testimonial evidence. If you take the last paragraphs from that page, I guess you need to redact whatever else is preceding that. And what are your objections to the portions that I've excised?
Judge, I object that these are the findings of Major Ramirez with the Dallas Police Department. So it's hearsay within hearsay. And so we don't have the context of the alleged rule violation, what he considered, and
But the rule is concisely stated there.
right.
In essence, can't quote it verbatim, but I think it's conduct that reflects negatively on the department.
Right.
Words to that effect.
Right, and part of his,
And it just goes on to state, you've been arrested for the offense of manslaughter. And that's conduct that is unbecoming to the department. And as a result of that, being terminated.
it's a conclusion made by Major Ramirez that it's hearsay within hearsay, and it violates the confrontation clause, and I don't have the ability to cross-examine Major Ramirez on the context of the rule violation and elicit testimony regarding that. Additionally, it is not relevant, the fact that she was fired from her job. We're not trying to say that she's still a police officer. The fact that she was arrested for manslaughter and booked into Kaufman County Jail is more prejudicial than probative, unless I have the opportunity to call the ranger and respond. Yes.
And Judge,
Wait a
again,
minute, wait. Everybody that faces a felony indictment somewhere along the way is arrested.
Right.
So your argument that that's prejudicial, more prejudicial than probative, is overruled. Now, I've tried to excise out all references to any testimony. The portion that I have directed you all to simply states what the rule is and what the finding is.
Right.
Your objection to that will be overruled
Well,
in as
Judge-
much as that is part of the business records affidavit that accompanies 402. Is there something else
nothing
in
else.
that big old stack of stuff?
Nothing else, Your
So,
Honor, that the
We
state would
have
plan.
fought for a half hour about the fact as to whether or not Ms. Guyger was terminated, but I want to make sure. I didn't rule on the application process. And I thought I was writing down your objections to 400. I don't think I did. Let me go back. As to 402, your objection that that's too prejudicial is overruled. The excise portion, I'm asking you to redact.
Yes, Your Honor.
And just so we're clear, you know what I'm talking about,
Yes, Your
Mr.
Honor.
Rogers?
Yes, ma'am.
At the very bottom?
Yeah.
Yeah,
Right.
okay. So you'll redact that.
Yes, Your Honor.
That will be admitted as to 402. 401, you have no objections to the social media accounts page. It identifies some other things, but the pertinent identifying information has been redacted.
Right, so just that one page,
And
correct?
did you take a look at that one that we're talking about?
Right.
Just so you can see it.
I don't know where.
I'm good with that, Judge.
Well,
I mean, I've seen it.
Anyway, and back to the initial application. Now, the initial application, you indicate that our application was denied for a multitude of reasons. Is that correct?
That's correct, Your Honor.
And
Or at
Mr.
least it just states that on.
I don't think they give a reason.
No, the defendant self-reported denied at Fort Worth, and then that was her first time with Dallas Police Department, which she was not accepted at that time.
Do they have rules that tell you?
They not specifically, no, Your Honor. The only other thing listed in that would be the marijuana usage.
And Mr. Rogers, I thought I had written down your objections to the first application denial.
There's the fact that she was denied by Fort Worth PD is more prejudicial, is not relevant if it's more prejudicial than probative, and the marijuana usage is not relevant and more prejudicial than probative.
And the state's response, Your Honor, is that this is punishment-based. The trier of fact can consider all information. I think especially in guilt innocence that there was discussions about our victims' marijuana usage.
I'm going to allow you to use state's 400. Your objections are overruled. Okay, I'm sorry. I know you all came in here and waited at 1 o'clock thinking we would have started right at that time. I wish we would have. Does anybody need a bathroom break? Because we're going to go until you all are done. Well, I mean, any of the attorneys. Okay, great. Let me ask her to bring the attorney. Exhibit redacted.
No, just 1 second, because if we're gonna keep going, we wanna make sure we get all this objections to the other evidence before we start.
Oh, okay.
Sure.
Sorry, Mama.
That's okay.
Judge, the defense and I are discussing, may I approach the witness?
Yes. I'm sorry, you said the objections were what? I'm sorry.
Judge, one, that's a different account name than is the social media that identified on the state's exhibit as one of her social media accounts. So, Judge, I object that they can't link it to a post actually made by my client to they can authenticate that those comments were actually posted by Ms. Guyger, that anybody could have posted to that. There's nothing unique about other people have access to your page, and so I think they need to show with certainty from forensic evidence that is tied to that there's no other way that anyone else could have posted that under that name. And 3, it's more prejudicial than probative.
Can I see State's Exhibit 401, page?
And Your Honor, my response to that is those documents were actually pulled off of the defendant's Pinterest account via search warrant by Ranger and had been tendered to defense counsel in discovery a long time ago. You have to go through and really look at what's on that. Go through the search warrant return to find what's in there. There were almost 1,000 or so images on that return, and we're only asking to offer 3.
So just so I'm clear, you all got a search warrant to search for the contents of Ms. Guyger's Pinterest account.
Yes, Your Honor.
And these are things that Ms. Guyger saved to her account.
Yes, Your Honor.
and they were provided to the defense. Did you
Yes, sir.
receive
Yes, Your
them
Honor.
as part
Yes.
of your discovery?
Yes, Your Honor.
And you object that they're prejudicial.
Yes, Your Honor.
The objection is on the wall.
And then last, Your Honor, the state would like to re-offer, and I think we've renumbered them, were text messages that were the substantive instance, which we marked as states 353, 354, and 355. The court at that time would not allow us
Is
to,
this the MLK and
yes, Your Honor.
let me make sure I read these. To 353, 354, 355, and 356.
Approach, Your Honor.
Yes.
Other individuals within that exhibit so I would object to those statements that other individuals made as hearsay, and the text responses from Ms. Guyger are not relevant and more prejudicial than probative. .354, Judge, again, there are texts that are coming into the phone that are hearsay, and any responses by Ms. Guyger with her phone, these text messages are not relevant and more prejudicial than probative. The probative value in both those exhibits is substantially outweighed by the prejudicial effect. In State Exhibit 355, the hearsay statement from Martin Rivera we would object to, and the response by Ms. Guyger is not relevant, and its probative value, if any, is substantially outweighed by its prejudicial value. And State's Exhibit 356, there are hearsay text messages from Martin Rivera, and the text responses from Ms. Guyger are not relevant, and the prejudicial value, the probative value is substantially outweighed by the prejudicial value.
Ms. Long?
Your Honor, the statements made by the defendant are statements made by the defendant therefore are not hearsay, and they are relevant because the jury can consider any statements that they may consider relevant to determining the appropriate punishment in the trial. As far as the statements made by the other individuals on the phone, those statements are not being offered for the truth of the matter asserted.
Your objections to 353 through 356 are overruled. They'll be admitted. Does anybody need a bathroom break?